to reduce litigation, to make the life of taxpayers and other associations simpler. And in that regard, various initiatives have been taken in last few years. One of the important initiative earlier was e-assessment, then faceless assessment. Now from 25th of September, faceless appeals before Commissioner of Income Tax appeals. And in this series itself, with the budget of 2020, where it was presented, a scheme known as Vivad Se Vishwas scheme was launched. Initially, the scheme was to complete, or rather, the first opportunity to the taxpayers was given up to 31st March 2020. But unfortunately, COVID happened and economic activities, general life got disrupted for many months, and that is how it was extended to 31st December 2020. Further, considering the difficulties in payments, etc., earlier the 15 days time was provided. But considering the difficulties, government has further relaxed it and allowed the tax payment by 31st March 2021. That means any Vivad Se Vishwas scheme form submitted by the taxpayer need not be immediately paid. It can be paid even up to 31st March 2021. So these kind of facilities have been given. I have been receiving some queries, and even yesterday, FICCI office bearers called on me. There was a request from their side that, sir, can the date of filing form number 1 and 2, that is Vivad Se Vishwas scheme, be extended. I discussed with them and I said that that is not possible and that is not required also. Simply because the difficulties with the taxpayers is with respect to the payment of taxes. For that purpose, already the dates have been extended. But as far as filing is concerned, the scheme is on for almost 9 months or maybe almost 10 months. And during this period, various doubts, confusions, or any kinds of questions, queries were answered. In fact, 2 different sets of frequently asked questions, FAQs, have come by way of 2 circulars, and most of the issues have been clarified in that. I know that still there may be some issues pending, and we have already forwarded our different principal chief commissioner charges in different parts of the country. They also forwarded the same, and board is working on it, and as and when it can come. But irrespective of that, I request the taxpayers and taxpayer bodies, tax representatives, to not wait for anything. The forms should be filed without any further wait, because even if some clarification comes, it may only help, that's all. And even if the form is filed and tomorrow it is found that the particular assessee is not eligible, the worst scenario will be the form will be rejected, nothing more than that. It may not have any penal consequence. So we should not unnecessarily wait for something to come from the CBDT. It will come, but we should go ahead with our preparation. So coming to the, in general, I'll just briefly discuss, and then my officers, Amrapalli, would be discussing the various issues, particularly the nuances and scheme as such, and Mr. Parbat, PCIT Central, will be discussing the various aspects and issues raised so far, and the replies and rather response from the department and clarification in those regards. So this is how we'll be doing. If I in general discuss the scheme, who are eligible, so basically all taxpayers where the appeal is pending as on 31st January 2020 at any stage. It may be commissioner appeal, it may be tribunal, high court, or honorable Supreme Court, or even DRP, or writ petitions in high court. All of them are eligible. So that is very clear. And what they need to be paying: age against tax, interest, penalty, they will be required to pay only and only tax in those cases where the decisions are not in their favor. But the cases where there are favorable decisions of tribunal, high court, or supreme or other forums, then they need to pay only 50% of the tax. Penalty and interest are waived there also. So this is how the scheme is designed. And there can be appeal for penalty, there could be appeal for interest also. In all those categories, you will be taxpayers will be required to pay just 25% of the tax demand. Like 1 crore penalty is there, the taxpayer is required to pay only and only 25 lakhs, and then the entire penalty will be settled. So this is how the scheme has been designed. Then, as I told you, the last date is 31st December, and there is absolutely no possibility of it getting extended. So remaining 9 days are left. So we have to really work very hard. Taxpayers, taxpayer bodies, and tax representatives all have to really work hand in hand so that all the disputes are resolved. In fact, countrywide, more than 6 lakhs disputed appeals are there. Even in our Karnataka and Goa charge, more than 25,000 such appeals are there. So I would expect, and Karnataka being a taxpayer friendly state, people are more compliant here. I am sure they would definitely adopt this scheme, and they would reduce the litigation to the extent possible. Now I come to the advantages. What are the advantages if anybody adopt this scheme? First and foremost is it will reduce the litigation and consequential cost of litigation, because any kind of litigation will require huge cost in representation, then uh, ad hoc payment, then subsequent payment, and all those things. So those will automatically be. Then if the taxpayer adopts this, the payment will be made by 31st March, and till then, no recovery will be required. So that way, there will not be any demand to be paid before that. Then unnecessarily monitoring will reduce, because any taxpayer may have 2, 3, 5 appeals going on. They have to constantly monitor those, that when the hearings are there, whether the counsel has prepared proper representation or not, all those things are to be monitored by the taxpayer. So those requirements will not be there. Then in basically the cases where the favorable order is there, just by paying 50%, they can actually settle the matter. Then this will reduce the time and effort in unnecessarily going behind all these. And foremost is this will avoid the risk of negative order at any stage. Apart from that, if these are settled, then there will not be penalty. Obviously, subsequent to that, there will not be any prosecution. So all these actually issues, all these advantages are there if we adopt this VsVs. Now, there may be some taxpayers might be thinking that, okay, I have a favorable order by Commissioner Appeal, department is in tribunal, or I have a favorable order of IT-18, department is in High Court, or the same way up to Supreme Court. They might think that since I have a favorable order at one stage, why should I bother? But that is not the case, in fact. I would like to just mention some of the instances where the favorable order at a lower stage is reversed, and that has caused innumerous problems for the taxpayer. In fact, I'll tell two live cases which I have encountered in last few years, and then I'll also deal with the decisions of Karnataka Tribunal, Bangalore Tribunal, and Honorable Karnataka High Court also reversing the decisions of our tribunals, which were in favor of the assessee earlier. So there is always a risk involved. One should never think that it is in my favor at one stage, so I am going to the winner at all along. That may not be the case. And now, as we all are aware, that at commissioner appeal level, the appeals are going to be decided in a faceless manner. So even there, if the slightest possibility of confirmation may be there, because the representation will be mostly through emails or submissions to be given to the queries raised. So there may be a possibility that even the some scope of confirmation is there, then the addition might get confirmed. And once the additions are confirmed, as per the departmental practice, when the matter is in tribunal, 100% demand is recovered, and that is inclusive of interest. So that will be unnecessarily burden on the taxpayer. As I was mentioning, the how the catastrophic effect can have if a favorable order at some stage is reversed at some later stage. In fact, I recollect one of the search group in Ahmedabad when I was posted there in central charge in 2002. Rather, search was 2000, and we made the assessment in 2002. It was roughly 45 to 50 crore demand was there at that time. Tribunal, that CIT appeal order came in 2004 in that case, and that was reduced to just 2.5 crore demand. SEC was happy that the entire burden is reduced, but in 2012, the matter has been decided by tribunal there. Our CIT DR, we argued there, and the whole thing is reversed. So those 45 crore for almost 8 years, interest and all those things, the demand has gone very high. And tribunal being the highest fact-finding authority as far as issue of facts are concerned, that has really caused huge burden on the taxpayer, and followed by penalty and other things. Similarly, recently I was just going through a decision of Madras High Court when I was in Chennai, Rakesh Sarin group. There again such took place in 2005, and tribunal decided in their favor. Entire demand was knocked off. And suddenly in High Court, in 1 year, in fact, that decision has come, and that has reversed the tribunal's decision. From 2005 onward, you can one can calculate the interest and other burdens. It is a huge liability. In fact, 30-40 crore liability has turned into maybe 100 crore. So that kind of risk is always there. In this kind of situation, if say 50% payment is made, even if it is favorable to the department, it is only on account of tax, interest, etc. need not be paid. So these are two examples I have given, but I have recently analyzed many orders of ITAT Bangalore in which favorable orders of CIT appeal has been reversed. And these are basically on exemption under section 10A, claim of exemption of trust income under section 11, income of charitable trust under section 215, bad debts under section 36(2), disallowance of capital expenses, disallowance of prior period expenses, disallowance of deduction in case of cooperative societies under section 80P2A, deduction under 37 and 40AIA, income under section 28(5), MAD computation under 115JB, deemed dividend under 222E, interest disallowed under 36(1)(3), and penalty getting confirmed under 271(1)(c), deemed income or addition under 68 and 69, disallowance or deduction under 54, 54F, G, etc. from capital gain computation. In all those issues, CIT appeals order has been reversed by ITAT Bangalore. So what I mean to say is that even if you have a favorable order at one stage, one should not be extra confident that okay, now this issue is in my favor permanently. Litigation always have two sides. There is always a possibility that at a later stage it may get reversed. Similarly, the favorable orders of ITAT Bangalore has been reversed by Honorable Karnataka High Court on various issues. In fact, some of the orders I have recently gone through, those are like on TDS interest under section 201(1)(a), disallowance of expenses under 37(1), again MAT computation under 115JB, deduction under 80IA, income diversion at source under section 4, addition under section 69B, late deposit of PF and ESI under section 36(1)(5)(a), registration of trust under section 12(AA), where Honorable High Court reversed the decision of ITAT in which the registration was allowed. Then international tax related cases where section 9 read with 40 AI, read with 195 income of non-residents. In all these cases, decision of ITAT has been reversed by Honorable Karnataka High Court. Even Honorable Supreme Court has reversed Honorable High Court's orders in many cases. In a landmark decision in the case of PCIT versus NRA Iron and Steel Private Limited, that is reported in 103 Taxman 89 in 2019, addition made under section 68 on account of bogus share application money deleted by High Court has been confirmed by Supreme Court. Quantum was almost 18 crores in that case. Similarly, on the issue of 43B, 80IB, etc., High Court decisions have been reversed. So, what I wanted to point out to the audience present here is that even if we have a favorable decision, assessees have favorable decision at one stage, one cannot predict reasonably that that same situation is going to be there till Supreme Court decisions are there. So it is always in the interest of everyone to avoid litigation, to avoid uncertainty. And in favorable cases, the charges are only 50%. That will take away the burden of penalty, that will take away burden of all kinds of interest and consequential prosecution. So all these benefits are going to be there if we apply, we adopt the scheme, else there would definitely be risk involved. So I would urge the taxpayer bodies, taxpayers and tax representatives to kindly consider uh, the overall aspects and try to reduce the litigation. In fact, there may be cases where the tax demand is nominal, very small. It is very easy to settle those cases. Similarly, the penalty appeals are there. Just by paying 25%, one can settle those penalties. So it is actually advisable to do it in time. Otherwise, in the course of time, 5 year, 10-year passes, then the liability may become 2, 3 times of the tax liability. So one should really take care of that. Then there are various stages of appeals. It can be before CIT appeal or DRP. In ITAT, there can be assessee's appeal or department's appeal. In High Court, again, assessee's appeal, department's appeal. In SLP, Supreme Court also, there can be both the categories, assessee's appeal and department's appeal. Before CIT appeal, as I told, that maximum appeals are pending at that level. And now with the faceless scenario, in wherever any potential or any issues are there, there may be possibility of confirmation of board order. So there may be demand and liability subsequently, may be advisable. But wherever the appeal is pending, assessee's appeal is pending before ITAT, High Court or Supreme Court. That means there are decisions against the assessee in earlier level. Assessee's appeal in ITAT means CIT appeal decision against. Assessee's appeal in High Court means ITAT's decision is against the assessee, and in Supreme Court means High Court decision is against us. In this situation, one should definitely go for it, because already 1 or 2 appellate forum has expressed their opinion and given the order that this is what likely to be the scenario. So in that situation, I think the risk involved is very, very high, because it is not just the tax liability, it will have interest, it will have a penalty, and penalties are confirmed, then prosecution. So in wherever the assessee's appeal are there before ITAT, CIT, Honorable High Court and Supreme Court, I strongly advise that one should not even think twice, because those are the fittest possible cases where they should assist, taxpayers should really get relief from other consequential actions. As far as the department's appeal are concerned, definitely those are the cases where assessee has favorable orders in earlier stages. But as I mentioned, there are possibility of reversal at the next stage. One should take that into account. If the reversal takes place after many years, the liability will be very, very huge. So that uncertainty is going to be there in the minds of taxpayer, and of course the litigation, cost of litigation, all those things, if you take into account, then probably the payment of 50% taxes in the cases where department's appeal is there, I feel that may still be a better option. So considering all these things, I strongly suggest that like we have about 25,000 appeals pending at various stages. at least 50% of that should come forward. And wherever some issues are there, I have told all my officers in entire Karnataka and Goa region to facilitate that, to be available to your services, to be available to your queries, to handhold you and your the taxpayers to facilitate filing this. Because for as far as the filing is concerned, the date is fixed. Department is not asking any payment till 31st March. Taxpayer can pay at its own ease and pace by that time. But if it is not filed by this time, then the bus is missed. Then on 1st January, there may not be any possibility of filing the same. So this is the time, last one week is left. Let us all collaborate and make sure that maximum litigation is reduced. With these words, I thank everyone to participate, and I ask the coordinator to proceed further. Thanks a lot.
Thank you very much, sir, for taking us through the significant aspects of this remarkable scheme, Vivad Se Vishwas, dispute to trust. Sir, you had highlighted the thought process which has to go into in dealing the legacy issues, and that will immensely help in reducing the litigation. Thank you very much, sir. Now I request Principal Commissioner of Income Tax, Panaji, Madam Amrapalli Das, to give us an overview and the salient features of the Vivad Se Vishwas Act. Over to you, Madam.
Namaskar. I am Amrapalli Das, and I am very privileged to be following our Principal Chief Commissioner's opening words for today afternoon. I have been asked to speak about the salient features of the scheme for the benefit of all our guests today. I welcome all the participants, the trade associations, the bar associations, the Institute of Chartered Accountants, the stakeholders who are have been kind enough to join us today. Sir has already spoken of many of the features of this scheme, which are of benefit to the taxpayers. I would also like to point out that as departmental officers, we are equally keen to see the end of many items of litigation which have been a cause for consuming our time and resources, and also creating a lot of paperwork for all of us. At the cost of repetition, I would like to point out that the Vivad Se Vishwas scheme has been brought in by the Government of India to bring an end to vexatious litigation, to enable taxpayers to find peace of mind, to save their time and energy from litigation that may have dragged on for several years, and also from the point of view of revenue, to generate taxes and to bring in some much needed revenues for the government. The scheme was tabled by the Honorable Finance Minister before the Parliament on 5th February 2020. After receiving the assent of the President, it became law on the 17th of March. By that time, there had already been lengthy discussions with the taxpayers, with stakeholders. We had received many queries, and we were ourselves gratified by the amount of interest that the scheme had received from the representatives of the assessees. Many questions had been raised, all of which were then, which found some clarification in the frequently answered questions, the answers which were issued subsequently on different dates. So far as the FAQs are concerned, we feel that they have covered almost all the issues of a general nature. We are aware that there are still many queries of specific cases, and the department shall be entirely at the disposal of the taxpayers and their representatives for the remaining days of up till 31st December for filing of applications, and thereafter for other questions relating to tax payment and other issues which are going to come out of today's discussion and subsequent ones as well. To repeat a few points already raised by our Principal Chief Commissioner, this scheme is of great benefit to assessees who have been mired in litigation. There can be no scheme more beneficial for someone who is spending money on representing his or her or its case before various judicial fora. There is a requirement only of payment of tax if the issue in dispute is related to a tax demand. Where the assessee has received a favorable order in an earlier stage of appeal, then the tax to be paid is only half. Penalty is to be paid, penalty and interest, only 25% of the amount in dispute. The fact that the assessees will benefit to the extent of waiver of interest, protection from penalty, from prosecution, is only one part of it. In my opinion, the major advantage that the taxpayer will receive is in the gaining of peace, in bringing an end to litigation, and in saving his time and resources for looking after other aspects of his business rather than battling the department in various courts. So the scheme covers any dispute that was pending as on 31st January 2020. Speaking very generally, if there was an appeal which had been filed before 31st January 2020, or where the time was still available for filing of appeal, even if the appeal had not yet been filed, in any of the appellate fora, whether before the CIT appeals, before ITAT, High Court, Supreme Court, the assessees are entitled to file an application and settle their disputes. The taxes, the demand which can be settled include tax, penalty, interest, fee, and tax deducted at source disputes. Even where assessees had filed revisions under Section 264 before 31st January, such cases can also be settled. Cases which are pending before the Dispute Resolution Panel, the DRP, cases where the DRP had issued directions on or before 31st January, but no order had been passed. And even those such cases where the disputed demand is less than rupees 5 crores for any single assessment year. There are very few cases which have been left out of the scheme. And while those are the exceptions only, but I will go back to them. Obviously, such cases where the disputed tax is more than rupees 5 crores in a single year. Prosecution, where prosecution has already been filed by the department. Cases relating to undisclosed foreign income and assets. Cases completed on the basis of information from foreign countries. Cases covered under various acts such as the Narcotic Drugs and Psychotropic Substances Act, Special Courts Act, Unlawful Activities Prevention Act, the Prevention of Corruption Act, the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, Prevention of Money Laundering Act, and the Prohibition of Benami Property Transactions Act. These would still be a very small number out of the appeals pending before the judicial authorities. According to me, almost the largest number of cases would be those which are before the CIT appeals. And I would consider that if we can settle even as our principal CCIT has already said, even half of those appeals, it would be of a great advantage to the assessee and also to the department, which would be then able to free up its officers' time for other activities. Our department has had a great response in the beginning when in February and March, many applications were filed. The intervention of the pandemic obviously resulted in a slowing down of the filing of applications. The fact that the economy took a terrible beating over the past several months has meant that assessees may have had some hesitation regarding their ability to pay the taxes to settle their disputes. The extension of the date for filing of applications till 31st December and the time given till 31st March 2021 for paying up the amounts which will be required under this scheme is a step in this direction. I wanted to mention that even if the amounts are not paid up by 31st March, the assessees have the option of paying the additional amount of 10% and paying even after 31st March. One of the assurances which has been given to us by our higher authorities is that we are not to take any adverse view if at all applications are filed, but the assessee is for any reason, probably for reasons of financial constraints, unable to make the payment by 31st March. We would encourage all of you to explain to your clients that the deadline for filing is 31st December. They should not miss the bus. If at all, the taxes cannot be paid in time by 31st March or even subsequently, the department is not going to take any negative view about this. The department is well aware of the constraints under which our taxpayers are at this point of time. But with every sign that the economy is in a recovery mode, we hope that all these declarations, the applications which we receive right up till 31st December, will be honored. So far as the resolution of the disputes are concerned, the scheme is extremely simple. The assessees are to file their declarations in Form 1. The declaration is not a complicated form. Of course, all of them will have the assistance of their representatives. Form 3 is to be issued by the principal CITs concerned after ascertaining, after certification of the demands and the amounts in dispute from the assessing officers. Once the amounts have been paid, Form 4 is to be filed by the assessee, and Form 5 is the order of final settlement. Again, we are trying to expedite this process. We are trying to ensure that there is no delay between the payment of taxes and the issue of Form 5. Directions have been issued at all levels to ensure that there are no delays from our side. There is only a limited window now left for filing of applications, and we shall be prompt in disposing of all the applications as and when they are filed. The benefits of the scheme have been enumerated by our Principal Chief Commissioner. I think all of you are well aware, but just to repeat, the taxpayer will receive waiver of interest. He will, even if penalty has been levied, if he settles the tax in dispute, then the penalty will also be waived. Where the dispute involves penalty, he only has to pay 25%. If the dispute is of interest, he only has to pay 25%. Where he has received a favorable order, he only has to pay 50% of the tax. And if it is the assessee in appeal, then he would have to pay 100% of the tax, but still receive complete waiver of interest and protection from penalty and prosecution. Settling of the disputes will not set any precedent. So neither can the taxpayer nor the department claim or show this settlement as a precedent in any other year. However, those issues will not be reopened, will not be revisited in any manner whatsoever by the department once the dispute has been settled. The scheme allows for refund of any amount which has been paid by the assessee in excess of the amount which is required to be paid under the scheme. One of the points which our principal CCIT had touched upon is whether the declaration can be revised. That has been clarified in one of the FAQs, that the declaration can be revised any number of times until the issue of Form 3 and before the filing of Form 4. So if at all there is some question about the quantum or about the manner of filing the declaration can always be revised, and the department will assist the taxpayer and their representatives in this matter. The CBDT has, of course, retained the power to issue instructions and directions for easing any difficulties which arise. I would again point out that it is a very simple scheme. The assessees can be brought to realize the benefits by the intervention and by the persuasion of their representatives. We look to the chartered accountants, the ITPs, the advocates, the trade associations to please disseminate the message regarding the advantages of the scheme for the taxpayer, to please explain to them that this is a very, very beneficial scheme, and it does not come, this opportunity does not come often. They should take the full benefit and partner the department in ensuring that this scheme is a grand success. As our principal CCIT mentioned, there are 6 lakh appeals at various fora. About 10 lakh crores of demand is tied up in these appeals. Let us bring an end to litigation as far as it is within our power. This has been the attempt of the government for the past several years. We have ourselves withdrawn appeals at various fora, which all of you are aware of, in order to reduce the burden of litigation, both for the assessee and the taxpayer. This is the next big step. This is the way to ensure that this, the number and quantum of litigation can be brought to an end. I hope that you will all rise to the occasion. The department is waiting to help you. Thank you.